Hey, good morning, everybody. Welcome to our 8th annual Scary Stories, or I guess Scary Stories from the HR department. We really appreciate you attending, and we hope to give you some practical and legal advice for the next hour. We've got a packed agenda. We're going to talk about medical marijuana, the new law that that's coming into effect in January of next year. Um, the daunting social media issues that we have to face when our employees post things that we don't like or reflect poorly on our business. We're going to talk about AI and some issues that relate not only to legal implications, but just practical implications. An update on non-compete issues and the ADA and FMLA. So we're going to go ahead and get started because we are jam-packed. There we go. So the first topic is this new medical marijuana law. We've received a lot of inquiries over the last 6 months or so, and we want to talk a little bit about what the law is and how you can implement it. So Kentucky passed a law through, Executive Order 2022-798, which allows for which makes legal the possession and use of marijuana for medical reasons. And there are only a list of 6 or so different medical conditions that qualify. So that's really important, that you can't get this card and employees can't say, well, I take it for medical reasons without having one of these conditions, and they must have that card. You can go to KYMedCan, KYMEDCAN.ki.gov for a little more information. But the conditions include cancer, chronic seizures, chronic pain, multiple sclerosis, chronic nausea, and PTSD. It's very narrowly limited. So those are the only ones that qualify. So the important thing for you to know is that, first of all, you don't have to permit marijuana use, even in their off time. So you can still have a policy and make disciplinary decisions if people test positive for marijuana. However, if they have a disability, if one of those 6 or so conditions qualify as a disability and they have the medical card and take marijuana for that disability, you may have to exempt them from the policy, zero tolerance policy for marijuana use. So that is something that is really important for you to understand. However, it's not unlimited in the relief that they get from the policy. So, for example, if employees use heavy equipment or equipment that's dangerous, you do not have to exempt them from a policy. So safety sensitive positions, I would say positions working with children, maybe even the medical field, you can probably, say that even the medical card isn't going to exempt them from the policy, and that you can still have a zero tolerance policy. So what happens? Practically speaking, an employee is going to inform you before a drug test, hey, I've got this card, I'm going to test positive. Let's say you determine it's a disability. They are not in a safety sensitive position. Maybe even get information from the physician that they use the marijuana in so much time before they attend work that they will not be impaired, because you never have to tolerate an impaired employee under any circumstances. But you have this employee that you're exempting from the policy, but then what do you do? So, again, you can get more information from a physician about when they're using marijuana to make sure they're not going to be impaired at work. You can then determine, if it's a safety sensitive position, whether you're going to exempt them from the policy. So, like I said, in Kentucky, we have passed this law to make marijuana legal in limited circumstances. However, it's still a federal crime to use marijuana, and therefore the ADA is not going to protect an employee from or allow them to receive an accommodation for medical marijuana. So a little bit different in the law, but we're in Kentucky, and so you just need to understand that we might have to make those accommodations. So it's something that I always remind people, medical marijuana should be viewed no differently than any other prescription drug that has side effects that could cause impairment. So you'll treat that as though it's a drug that causes drowsiness or fogginess or anything, where if it's going to impair their ability to do their job, it would be a direct threat and you don't have to accommodate it. So again, just understand what this law is. Make sure that you have a policy, and we'll send these slides out, but here's a sample of a policy that puts people on notice that while it's legal in Kentucky, we as an employer are not going to exempt everyone from from marijuana use on drug tests. But we will follow the law with respect to any reasonable accommodations. And please, please, please do not adjust your hiring or interview processes to ask if someone has a medical marijuana card or is using marijuana legally under these circumstances. So just a brief overview. We can get into some detail if you have questions when it comes up in your workplace, but I want to turn this over to Claire and have her discuss our next scary topic, which is social media.
Okay, so our next topic, we're going to call an unquiet place, and we're going to talk about social media in the workplace. So the first question is, do you need a social media policy? I would say yes. Now, social media, 77% of your employees are most likely on social media. The majority are going to use social media while they're at work during their downtime. And so you do need to have a social media policy to help protect your reputation and brand of your company, to make sure that they're not posting anything that's embarrassing, disclosing confidential information, or things that could potentially land the company in trouble. With that caveat, request, I have a caveat. You want to be very careful when you draft a social media policy, because the National Labor Relations Act discusses how employees can engage with each other to engage in protected concerted activity. And we're going to talk about that. So if drafted poorly, your social media policy could run afoul of the National Labor Relations Act, and you just don't want to get into that kind of trouble. Okay, so first things first, let's definitely adopt a policy. But before we do, we want to make sure that we understand what the NLRA protects. It protects an employee's right to engage in protected concerted activity. So what does that mean? Protected means they're allowed to have discussions regarding their wages, hours, and working conditions. Concerted means one or more, two or more. So anytime somebody posts on social media and someone reacts, or it is read by somebody who is a peer, a coworker rather, that is concerted. And so pretty much anything that comes under social media, guys, is concerted activity, as long as it relates to wages, hours, and working conditions. The reason that this is so important right now is there was a case that came out in August of 2023. It was called Stericycle, in which the NLRB said any facially neutral policy, so a policy that doesn't attempt to impinge on somebody's rights to engage in protected activity, anything that's facially neutral, if it tends to chill an employee's rights, or they perceive it, they reasonably perceive it to, so not that it does, but that it could, is unlawful. So it just really broadens the whole spectrum of what could be unlawful. And this is in direct conflict of what came before. Now, given the election, we might spin right back over, but for now, the NLRB is being very proactive in reviewing folks' social media policies and handbooks, to be honest with you. So what does that mean? It means we need to look at our social media policy. So I went online and I just did an AI search, and I said, if I wanted to have a social media policy, what would it say? And this is what it came up with, the bullets. Adopt a social media policy to encourage appropriate employee use, discourage employees from using social media to disparage your managers and peers, prohibit employees from disclosing or misusing confidential or proprietary information, and don't allow social media to harass peers. So doesn't that all sound great? It's all facially neutral. There's nothing that seems like it would violate the NLRA, but it does. Okay, so all of the devil is kind of in the details on this one. So every employee is lawfully allowed to disparage their managers and peers to each other when discussing their wages, hours, and working conditions. And there's a ton of cases going back for years and years and years, since when I first started my career 20 years ago, 25 years ago. Oh, that made my stomach hurt. But regardless, it has always been the law that you can disparage your managers and peers. You can get online and say, he's a jerk, Brian. is such a jerk. I can't believe he said blah, 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 blah. And I'm looking at Brian and he's giving me the nasty eye. That's completely lawful as long as you are talking about wages, hours, and working conditions. So saying disparage is a hot button issue. I would never do it unless you're going to describe what that specifically means. I would exclude that completely. What you can say is that you're not allowed to disparage products or services of the company. That is completely off limits. So the next one, prohibit employees from disclosing or misusing confidential or proprietary information. Sounds great, right? We don't want that. However, what do you mean by confidential information? Well, wage data is often confidential. So are benefits. Those are confidential. So are people's contact information, your employees' contact information. So rather than saying you're prohibited from disclosing or misusing confidential or proprietary information, you want to describe what confidential information you're talking about. Maybe you're going to prohibit them from disclosing any confidential information that they receive as a consequence of their job duties, because that you can do. You can say, if you work in HR and you have access to confidential information, you're not allowed to disclose that. What you can't do is say, if Cindy told me how much she makes a year, you can't disclose that information because Cindy's information is confidential. Well, that's probably true, but she shared it with me, and so now I can share it with everybody. All right. So again, the devil is in the details. One of the limitations we should discuss, though, is an employee will lose the protection of the act if it's egregiously offensive or knowingly or deliberately false. So the information that they share. Oh, I forgot. Don't allow social media to harass peers. So the board has decided that any kind of union campaign is just inherently conflict laden. And so when you use a general term like harass, it gets conflated with, well, does that mean arguments about whether or not you should unionize? What does harass mean? Does it mean sending a bunch of tweets to somebody or sending a bunch of texts to somebody? What exactly does harass mean? And because it's facially neutral, they'll say if an employee reasonably believes that it is overbroad and that it impinges on their rights, then it's unlawful. So I generally circle back to my company's harassment policy, and I define that specifically versus leaving it kind of open. So how much of a threat is this? Well, last Friday, the National Labor Relations Board in Oakland issued a complaint against Apple, alleging that the tech giant interfered with efforts by an employee to promote pay equality and unlawfully fired her months later for making her future employment tied to ceasing these activities. So basically what happened is an employee went on Slack and started a new team account and brought all of her team members in and started talking about their wages. There was a policy prohibiting folks for creating a separate Slack channel. And so she was told if she continued to do it and didn't disband the Slack channel, she would be fired, and then was subsequently fired. So the NLRB issued a complaint. And so I think that this is a real threat, and for at least right now, the NLRB is going after folks. So it's something that you should talk to your labor lawyer and employment lawyer about. Okay, so you have a policy. It complies with the NLRB. It is not overbroad. And you still have an employee violated. What now? So we deal with this a lot. And I would say the first deep breath, let's discuss what the post was about. Was it protected? First question, always the first question. Was it about wages, hours, and working conditions? All right. Let's assume the answer is no. Second, let's talk about what the potential impact was. Does it affect confidential information? Does it affect proprietary information? Does it harm the employer, the company reputation, their products, their services? Does it harm your goodwill? Was it political? These are all issues that we need to talk about. Now, please know there are no free speech rights with private employers. So we've kind of dealt with this a lot, with the various kind of wars going on. People have different opinions about politics. People have different opinions about, geopolitical issues. And so oftentimes they'll go on their social media and they will comment on them, and that can create offense among peers and coworkers. What do you do when that happens? What do you do when they post something like that? Well, if you feel that it impinges your ability to have your employees work well together, or if it affects your brand, your reputation, deals with confidential information, you can ask the employee to remove the post. And you can talk to employees about how the violation of your, wonderful social media policy, how it affects the work relationships and work environment in your corporation. So train them on those policies and warn the employee in the future that similar posts might result in disciplinary action. So you want to kind of go through those things. Now, again, I would be very conservative with discipline when it comes to social media posts. You really want to only deal with the things that affect your products, your services, your employee relations, your goodwill. A lot of times I think we get angry about social media posts, and the best thing to do is just let them go because they'll fade away. Whereas if we make a deal about it, we bring it up, oftentimes that becomes a PR nightmare. So just a word to the wise. Okay, so some employees are prolific and get in some trouble. And so we had some fun looking at all of these odd posts. So the first one is a young woman working as an account executive for an ad agency participated in a client pitch. They began working on an ad campaign, and the team lead cautioned everybody that the campaign wasn't finalized and should be kept confidential. The young woman posted an Instagram of a photograph of her in the internal office celebration. She didn't mention the campaign, she didn't mention the client, but in the background, there was a photograph that had the new client's campaign. I mean, it's just a nightmare. Nightmare for everybody involved. And of course, she was
True scary story.
true scary story, and she was promptly fired. And I will tell you, this is going to happen more and more. We have received so many calls about Be Real posts. So Be Real is an app where people take a picture at a certain time of day. And I'm sure you've noticed everybody gets out their camera, takes Be Real, although I think it's fading. Be Real is fading. But anyway, if you are in an office where you have confidential files or confidential information, make sure to include that prohibition in your policy saying Be Real cannot be used in this office. There's also a couple of TikTok trends that you guys need to be aware of. There's, bare minimum Mondays where, the start of the work week, the advice is basically practice self-care, don't do anything on Monday or do the bare minimum. You want to make sure you have clear policies and expectations for dealing with those kinds of trends. Be aware that those trends exist. And if you start noticing your folks utilizing or posting on those, bare minimum Mondays is pretty egregious. You want to make sure that you have policies in place to deal with that. But you also want to take that information in stride and say, if I have 10 people who are posting about bare minimum Mondays, what does that say about my engagement? What does that say about how folks are feeling about my company culture? And address it, put in place some incentives, make sure that you address any kind of deficiencies. And I would encourage you, if folks continue to kind of quiet quit, then you want to address that, because it does hurt goodwill if certain employees aren't bearing their own weight. Which leads me to quick talk, which I guess there's 2,500 videos, 82 million views. And the idea is folks videotape themselves quitting. These are great training videos, and I'm not kidding at all. Like, you guys should go on and watch. Anybody who does HR, anybody who is a supervisor, go on, watch these videos. It is such a display of what goes wrong, how to do it poorly. and learn from these videos. You know, a lot of these folks go in there because they feel like their supervisors or their managers or their HR folks aren't expressing empathy. So you'll see that over and over and over again. And sometimes you'll see folks doing it right, but it is a really great learning tool. We've already talked about it, implementing some of them in our training. Okay, so more funny stories. High school teacher, oh, this one's not funny, it's kind of gross. A high school teacher was fired after tweeting photos of herself scantily clad, claiming she got high in the staff parking lot. Other photos on her account depicted her smoking marijuana with the caption "naked, wet, stoned." She was terminated. This is all over. You can read the case. There were some other ones. Taco Bell, an employee was fired for tweeting a picture of himself peeing on the food, which makes me never want to go to Taco Bell ever again. A little bit less egregious, but still unfortunate. A nursing home worker who was posting on Be Real, again, Be Real is bad for this, posted a picture, but did not realize there was a naked patient behind him in the background. He was also terminated. Okay. Oh, this is another big one. A Chrysler contractor posted, "I find it ironic that Detroit is known as the Motor City, yet nobody here knows how to effing drive." Okay, so here's the interesting thing about this poor soul. He was in charge of Chrysler's social media. He thought he was posting on his private account. He was in the car. He had both accounts on his phone and just posted on the wrong account. Now, who knows what would have happened if he posted that on the private account, whether or not he would have gotten terminated. But needless to say, Chrysler did not want that posted out under their own social media, and so he was promptly terminated. Okay. So these are some of the things that we need to be aware of, some of the funny, sometimes gross, sometimes accidental, sometimes intentional social media faux pas that can happen. We ask you to check your social media policy, make sure it's compliant, make sure it deals with some of these hot topic issues, and then train your employees and make sure they know what the expectations are and some of the dangers. I mean, I have always found in my experience, when you use specific examples, employees are much more apt to pay attention. They're much more apt to be receptive to just a bland old policy. But make sure to consider the National Labor Relations Act when you draft. Okay, I think that's it.
Okay. Real good.
Go ahead. I was just going to lead you in, but go ahead.
Well, we're now going to switch to AI, which I think is scary for a lot of us. I'm in that generation where I didn't necessarily grow up with a whole lot of computer aided technology that my children have. And so there's a little bit of tension there. And I'm also of the age where I don't want to change, right? I want to do what we've always done. I neglected to mention at the beginning, if you want to throw a question in the chat, feel free to do so. We'll try to answer those at the end. But we've been using AI for years. Monster.com has been, generated by AI. Autocorrect is AI based, and chat boxes on websites. You see a little box, say, talk with me. So we've been using it, but lately it seems like every day there's a new application or a new piece of software, and it's creeping its way into the workplace under the guise that we're going to be more productive and more efficient. And we can have a whole day seminar on AI in the workplace, but today we're going to just focus at a high level, talking about how AI affects employment, employee relations, and management. Whoops. So, one of the things that, AI boasts is that's going to make our job easier. And I question whether it does. I mean, if I get on autocorrect and I want to type an expletive, it reverts it to duck instead of the word that rhymes with duck. And it's not quite the meaning that I want. And there have been I think there's been like a whole, t-shirt and meme economy that's come out of it where, there's lots of things that make fun of that. But how we use this AI and what we know about it is going to be extremely important because it could lead to legal liability. In preparing for this, I found that there were lots of meeting tools, writing assistance, transcription assistance, email management, project management, a whole bunch of tools I don't quite understand just yet. Maybe it doesn't really apply to the legal field, but I've had clients that have called and asked about the use of these tools. A couple of things we need to be aware of. Are the tools accurate? If you're using one for writing assistance or summaries of meetings, you're going to have to verify that the content that the AI generated is accurate, because otherwise, if you don't, then you are adopting it by acquiescence or silence. And if that piece of summary is included in litigation and it's not quite accurate, you're stuck with it. What about storage of information generated by AI? Does the software of the application have sufficient privacy settings to protect your and your clients or your patients' confidential information? And finally, we're going to discuss how discrimination or bias can creep into the use of these AI tools. So we're going to talk about each of these things, but the high level sort of concerns are people concerned about whether their jobs will be replaced. In the Port Authority strike not too long ago, one of the demands in their collective bargaining was, you need to promise that our jobs won't be replaced by AI or robots. And I don't think that it's generational, but it might be, but there's a concern amongst employees that AI is going to take over their jobs. There's also a concern, people like me, will I be able to learn this AI? I mean, I have trouble learning Snapchat, right? I mean, so am I going to be able to learn some of these tools that my employer is now either making me use, or everybody around me is using them, and maybe they're getting better results? Will it be accurate and biased? So I want to get into a few of these things. So, you might wonder, well, how is an AI or a robot going to discriminate? And so a couple of examples, and most of these have been created through experimentation. And so companies that have been using them or wanting to use them have engaged in experiments to determine whether AI is accurate and using discriminatory data. So facial recognition software has been determined that it has a hard time identifying people of color, and that could result in a bias or discriminatory act. One facial recognition software analyzed the emotional content of NBA player photos and found that the African American players had more negative emotions than white players. Now, again, I'm telling you this just to demonstrate that AI is not perfect. The robot is not perfect. And how that could bleed into your use of it is something we need to be aware of. Amazon was an early adopter of AI. It used a resume screening tool that had a bias against women due to the data set that it learned during its development. AI is only as good as what it learns from, or how it's trained and the data that's input into it. And in this particular example, male candidates, or the tech industry was more heavily dominated by men. And so the robots tended to gravitate toward male candidates. And it even picked out words like executed and captured in resumes being words that were more likely used by men, and therefore favoring male candidates. Again, not intentionally, but just because of how the computer learned. ChatGPT ranked resumes with disability-related awards and credentials lower than identical resumes with the references removed. Again, an experiment was done and determined how ChatGPT was ranking resumes. So what's Monster doing? What's Indeed doing? How are those AI tools being used? AI detectors reach incorrect conclusions about writings of non-native English-speaking candidates more often than US-born writers. Again, if you're using a software like Monster or applications like Monster and Indeed, what are they doing to screen out candidates? Google Ads are sending higher paying jobs to male users than female users. Again, so I'm telling you this, that if you're going to employ some AI in your workplace, you really have to understand how this program learned and what tests they have done to determine the bias and how to weed that out. The other thing is, you need to really understand how, what sources of information AI could be gathering. Is it using the internet, social media, or public databases? Because you are going to be responsible for any discriminatory event, not the robot, not the software. So you need to get all the information you need. Another example is healthcare software doesn't accurately analyze or diagnose patients, women or minorities, because most of the data that has been used in some of this AI software in the healthcare field has been through male patients. And so I use that as an example to understand how this software that you're using affects your industry in particular. And again, understand where the sourcing of the information is. So, like I said, this ChatGPT and other AI components can be helpful. We've all played around with it. We've all thrown something in there to get ideas, but is this something you can't rely on it, right? So there are numerous examples in the legal field of attorneys who used AI at the last minute to generate a brief, turned it in, and found out that the software made up cases. It's called hallucinations. It's interesting to read about AI and how it works and how it doesn't work, and it literally can make things up. And so this particular attorney got called out by the judge, and he said, yeah, I used ChatGPT, but I verified everything. Turns out he didn't because they made up cases. So how does that work in your business, right? What ethical considerations do you have in the use of these tools that can bleed into affecting client relations and employee relations? We used to worry about just plagiarism, right? Somebody just copying something, but we don't have, you can put something in the chat GPT and copy it and put it into yours, and there's not a plagiarism issue. But to me, it's sort of akin to hiring somebody to take your ACT, right? You're not getting my work product, you're getting somebody else's. So can we really evaluate whether the employee is able to communicate without the use of AI? Apple has got this tremendous campaign. Some of their ads are pretty funny. The most recent one was an employee named Warren who's sitting back in his chair. He's typing an email to his boss, and he's kind of a goofy guy. And he's like, "Hey, boss, this presentation needs a little jizzing up. Maybe we can figure that out, Warren." But he hits a button, and Apple changes it to, "Dear Mr. So-and-so, this presentation needs a little," it changed all the words, and it said, "With warm regards, Warren." And that's what the boss reads, and he goes, "Warm regards, Warren? Like, this is not the Warren I thought I was dealing with." And so what do we know about our employees if they're using ChatGPT? Can they communicate? Can they write a handwritten note if they're in a conference room and there isn't an ability to send a text? We need to really understand how our employees are communicating without the use of AI. And so that's something that I think are just some of the practical considerations when we're dealing with it. Like I said, employees are worried about job displacement. We have ethical dilemmas, privacy concerns, but I think it's really important to understand the effect on creativity, critical thinking, skills, and human interaction when we're using AI. There can be jobs that are created, and there can be jobs that are enhanced by the use of AI, but you really have to understand what you're getting into and the unintended consequences. And one of those will go back to me being in a generation that I'm not going to adapt to some new technology. Well, could you be accused of age discrimination if you're not training everybody? Or if do you have an obligation to provide training because the younger workers know how to use this AI, but maybe the older workers don't? What sort of disparate impact does the use of it have on your workforce? And again, with respect to age discrimination claims. And, I can't highlight enough any ethical dilemmas that might be associated with your particular industry that you need to be very cognizant of before employing AI or a different AI software. So, we thought employees were our biggest headaches. Now we have to deal with robots. And that's something that I think is truly scary as well, because there's so much we need to learn. And, if you go online and you read any interviews with the makers of AI, they're concerned about it and how it's being used as well. And we're jumping into it going, "Hey, wait, we can have a scheduling assistant. We can have AI note takers. This is awesome." Is it? We need to really understand. I'm not saying that it's not, but I think there are a lot of considerations that we need to use and to be mindful of, not only practically, but legally. So with that, I will turn this back over to Claire to talk about changes with non-compete issues.
Okay, first for this slide, I want to give it up to Brian because this is key. And I was really impressed with this one. I have nothing really to say with this slide except to appreciate it. All right. So first thing I want to talk to you guys about is the non-competes in Kentucky. We have KRS 216-724, and it deals with Healthcare Services Agency. This legislation governs non-compete agreements between healthcare service agencies and temporary direct care staff, contractors, and employees. Okay, it does not deal with contracts with either permanent or direct care staff. It doesn't deal with assisted living communities, long-term care facilities, or hospitals for placement of permanent or direct staff. Okay, so I just want to kind of make clear that it's a very specific group of people who are affected. And what this legislation basically says is that an agency can't restrict the manner in which the employment opportunities of direct care staff is contracted or employed. So that means no non-competes, no solicitations, thinking, stuff like that. It does create a cause of action for employees. The statute of limitations is 2 years or the later of the non-compete signed. They learn, it's all in there. So if you are in this very discrete group, or if you hire for this discrete group, you really want to know about this legislation. And feel free to call us with any questions. Okay, so getting broader in scope, we all knew about the FTC ban on non-competes. It was struck down, and that was in Ryan LLC. They basically ruled that FTC had overstepped their bounds, which, if you've talked to your lawyer beforehand, no one was surprised by this. It was incredibly broad. I would say it was far too broad for the purpose. And so the effect of it being knocked down is there is no ban. However, I will say this decision was subject to the appeal of the U.S. Court of Appeals and Fifth Circuit, and FTC did file an appeal on October 18th, 2024. So, we'll see how it goes. I think with the election, it's probably going to get buried. But, regardless of the FTC appeal, we also have to think about the Supreme Court came out with a case called Loper, which pretty much limits governmental agencies from making policies and setting action plans. It was the whole thing with Chevron. So without a Chevron deference to the FTC, I don't think this is going to come back. However, there are other agencies at play here. So regardless of how the FTC rules, non-competes are now big business. Non-competes are now in the public sphere, and people have started thinking about them. Private plaintiffs are starting to attempt to use antitrust laws to challenge non-competes. There's a couple of cases that came out in Missouri, and basically they said it is anti-competitive to have these non-competes. The court denied defendant department store's motion to dismiss, finding the plaintiff, which was a houseware store in Missouri, had adequately alleged the defendant using a non-compete agreement was abridged the Sherman Act because it was attempting to maintain a market share. So the employee, the plaintiff, basically said my non-compete should be thrown out because there's no legitimate business purpose that's not in violation of the Sherman Act or antitrust laws. The states are getting into the act as well. Right now, there are only 10 states that have no restrictions on non-competes. 4 states, California, North Dakota, Minnesota, and Oklahoma, have full bans. Every other state besides those 10 have some kind of restriction. Now, we just discussed our restriction. It's pretty limited, but these are becoming more and more prominent. There is, a proposal in the Kentucky legislature regarding non-competes. I don't think it's going to go anywhere, but, we'll see. What you do need to think about is if you have remote employees who work outside of Kentucky, you really want to look and see what that state's non-compete laws are, or non-solicitation laws are. So you can be compliant if you have a Kentucky form non-compete that you have all employees sign. So everybody who has remote employees should just call their attorney, check the state, and see if there's anything you need to be worried about. And we'll keep you posted on anything that comes out of Kentucky. Okay, so the other thing that you have to worry about is on May 30th, 2024, the NLRB sent a memo to all regional offices urging them to pull all non-competes provisions in any employment contract or severance agreement. Now, her belief is that these, except for limited circumstances, violate the National Labor Relations Act. So this is her thinking on this. So again, we talked about whether or not your policy will chill an employee's right to engage in wages, discussing wages, hours, and working conditions and bargain collectively, right? So that's what the act does. So how do you get there from non-competes? Well, what she said is it prevents employees from threatening to resign because the employer knows they can't go anywhere. They can't go to secure better working conditions at the competitor. They can't carry out their threats to resign concertedly, so all join together and do a mass resignation. They can't concertedly seek an attempt to go to a competitor. They can't solicit their coworkers to leave a bad employer. And they can't seek to bring in, other protected activity, other union organizers into that facility. So that's her reasoning. Is this law? No. But the regional offices have started to prosecute employers for having employment agreements and severance agreements that contain non-compete and non-solicitations. So June 13th, 2024, an ALJ for the NLRB took the first case up. It's going through the system. Once it gets to the board, and as the regional offices start implementing, it will become law. Again, unless something changes, which is highly likely with the National Labor Relations Board generally, but particularly now that the election has kind of shifted the winds. So, and keep in one thing I didn't mention from the last slide, but I should have, a follow-up memo from the GC instituted make whole remedies. So what does that mean? If a employer has a non-compete or non-solicitation that violates the law, the National Labor Relations Act, the employer not only has to get rid of that clause in their agreement, but they have to make the employee whole. And that includes not just back pay, but front pay. So if they weren't able to go to a competitor, if they weren't able to apply to jobs that they could have already applied to and so had to stay or be unemployed, then they could get damages for that. So they're really quite serious about this for right now. So how do you draft a non-compete that can withstand these changes? Well, first you speak to a labor lawyer and they'll handle it. But essentially what you want to do is you want to exclude any non-supervisory employee. So the National Labor Relations Act does not apply to supervisory employees. So if somebody can hire, fire, or discipline, you can have a non-compete all day long, then National Labor Relations Board can't do a damn thing about it. You can have a no solicitation. So you want to focus your efforts on folks who can hire, fire, or discipline. You want to narrowly tailor it to prohibit post-employment activities in the most limited way. Focus on legitimate business interests and ensure they're reasonable in time and in scope. And if you want to go outside of those parameters, it's a business decision. Just think about whether or not the protection of your confidential information, your proprietary information is worth the risk. Okay. Let's see. The next thing is a stay or pay agreement. So I use these a lot for my folks. So I was relatively surprised in October when the general counsel came out and said, stay or pay agreements are unlawful because they interfere with the right of the employee to engage in Section 7 rights. So what are stay or pay? They're training repayment agreement provisions. So we do this a lot for like trucking or, if somebody needs a particular license in order to drive a truck, drive a vehicle, oftentimes the employer will offer to pay for that training on the condition that the employee stay for a year. And if they refuse to stay for the year, then they have to pay for the tuition payment. Or if it's a class that the employee has to take or something along those lines. But the NLRB actually had a broad net on this. They said any educational repayment contracts, any quit fee, any sign-on bonuses. So if you give somebody a sign-on bonus and they quit within 3 months, and then you have a repayment clause, that is within this stay or play agreement. Or any contract requiring an employee to pay back an employer if they voluntarily or involuntarily separate. So that's what a stay or play. Okay. So there is a 60-day cure provision allowing employers to remedy any existing stay or pay provisions that are not lawful. So what makes a stay or play provision lawful? It has to be voluntary. So it cannot be a required qualification. So going back to my example of somebody who needed a CDL license, for instance, if that is required for their employment, not necessarily for that job, but for their employment, then you cannot have a stay or play provision. They have to voluntarily engage. So a distinction can be made for a promotion. If you hire an employee and they need a CDL license to get promotion to another job, then that is voluntary, okay? Reduce any provision to 1 year because the NLRB has said that that is an appropriate period of time. So you have to stay with us for 1 year, and if not, you have to repay. You have to disclose the payment up front, the payment amount. It cannot be squishy. It can't be the tuition cost. It has to be the exact number. And you have to disclose the definite repayment time period up front. So I urge you guys to look, if you utilize stay or pay provisions for anything, look at those agreements. And you have 60 days from the October deadline, from the October 24th memo to remediate those. Have somebody look at it, look at the repayment provision. Another wrinkle is if they're terminated for cause, there is no repayment under the NLRB, which is frustrating. Okay, I think you're next.
All right, so we're going to end today with a discussion and update on the ADA and FMLA. And again, Brian had a lot of fun with this. Yes,
the graphics.
we obviously need leave if we're looking like that. So we're going to discuss two different topics. We're going to discuss FMLA abuse and mental health issues with respect to the ADA, because honestly, we're getting more and more questions and notes from doctors about anxiety, depression, and other mental health issues. The EOC, I put up here a couple of different guidance that they've published recently. One under the ADA with respect to visual disabilities. And then, as we talked about earlier, there is an EEOC guidance on AI algorithms that impact people with disabilities and including visual disabilities. So they're good resources. So I want to start off with this case, and I've spoken about this case before, and I think it's really important for a number of reasons. It highlights how employers have to deal with mental health issues in the workplace, but it also is a really good example of what not to do on the employer side. This case made national news out of Kentucky, and it was a $500,000 birthday party is what it ended up being. So this particular employee, Mr. Burling, he suffered from panic attacks. He had a general anxiety disorder, but he was good at his job, and nothing about his job affected or nothing about his disability or his panic attacks affected his ability to do his job. Like most employer diagnostics celebrated employees' birthdays, and they would do so with a cake or whatever in the break room, and he was not having it. He thought this would trigger a panic attack, and he told his manager, please do not have a birthday party for me. The office manager forgot and set up a celebration, which caused him to have a panic attack. He comes in to work the next day and gets into a confrontation with his supervisor about how he didn't want to participate in this and he asked not to. And the supervisor responded with, you are stealing people's joy and to suck it up and get over it, which of course resulted in another panic attack. Now, some people may not want to celebrate their birthdays, and this supervisor obviously couldn't really understand that. Now, the supervisor denied saying that, which happens. We often have he said, she said statements. But she did say that her interaction with him was very disturbing, that he became red-faced, he had clenched fists, he asked her not to talk, and she, quote, feared something crazy was going to happen. He was escorted home and out of the building. Later, he was fired for making a supervisor feel unsafe, and they referenced an employee policy prohibiting violent or threatening behavior. Now, all of this is well and good, right? I mean, we have a situation where we've got someone who is engaging potentially in threatening behavior, and another one is fearful of it. They labeled him as having a panic attack and being crazy and being a threat. So an employer in this situation is faced with two lawsuits. Are we going to have a lawsuit because of disability discrimination? Or is this person truly a threat, and could he end up causing harm to himself or others in the workplace? And that's a tough decision for an employer to be in. But here, as I'm about to explain, all of this, the evidence at trial was exaggerated, that he did not act in that threatening manner, that she exaggerated how he was acting in order to get him fired. And that's what led to this $500,000 verdict. So, Gravity Diagnostics, wait a second. Gravity Diagnostics is, here we go. The employee alleged that he wasn't actually disabled, but he was regarded as disabled, meaning that there was some sort of stereotype or assumption that because he had a panic attack, he had some sort of disability. And that just wasn't the case at all. He was actually performing to expectations. After the panic attack, because he was fired, he alleged and sued because he was regarded as being disabled. Gravity Diagnostics, however, argued that, look, this guy wasn't qualified for the position because he was unable to do the job without having this panic attack. But the court found that, as we do in a lot of these ADA cases, that the employer failed to engage in the interactive process. And that while it took the position that Berlin was fired for safety concerns, the company said, look, we had safety concerns. We don't have to tolerate disability-related conduct that was violent or threatening. Again, that wasn't the evidence at trial. He ended up with $150,000 in lost wages, $300,000 in emotional distress, and an award of attorney fees. So here, the question is, was he qualified for the position? And he wasn't. His panic attack had nothing to do with his job. There was a triggering event, the party. That had never come up before, and he had clearly said, look, I don't want to party. So what are the important takeaways of this case, aside from, making sure that we are accurate in how we document employee interactions? So the court did say that you can fire an employee for misconduct, even if the misconduct occurs because of a disability. The next case is going to highlight the difference and explain this concept. However, and this is super important, you are expected to tolerate eccentric or unusual behavior that's caused by a disability, so long as they can perform the essential functions of the job. And they list a few factors to consider: the manifestation of the symptoms, the frequency of the occurrence, the nature of the job, the work environment, and the conduct. So here, there was no evidence that he needed an accommodation. There was a trigger, which was this birthday party. So maybe the accommodation was, I don't have to be forced to participate in birthday parties, but he otherwise was able to do his job. And so because of that, this employer ended up tagged with a large verdict and an unpleasant case to have to deal with. So it's just a good reminder when we're dealing with mental health issues in the workplace that also correspond with safety issues. We have to carefully review our employment decisions and how we are going to treat the employee. We got to be mindful that we don't regard someone as being disabled when they actually are not. And again, do not exaggerate a justification for the adverse action. Make sure that it is documented in a way that is helpful and accurate. So this Johnson versus L'Oreal case is one that is similar but different. The employer did everything right, and also highlights what you don't have to tolerate with respect to mental health issues. Ms. Johnson was an assistant vice president for L'Oreal. She did a great job. She apparently had no issues up until the time she was diagnosed with anxiety and depression. And then she started having excessive absences, had a drop in performance metrics. She was insubordinate. And she started sending some really antagonistic text messages and engaging in communications that were threatening. In this one, she said she was about to crawl so deep and far into another employee's ass that he will think she lived in his effing small intestine and would destroy him. Now, that's a little threatening, obviously, very inappropriate, especially from a vice president. She attributed it to her anxiety and depression. Now, we just said in the last slide, you don't have to tolerate misconduct, even if it is related to a mental health disorder. I don't think that qualifies as an eccentricity that we would need to tolerate. So unlike Gravity Diagnostics, L'Oreal actually attempted to engage in the interactive process to find out what her trigger was, right? His trigger was the birthday party. For her, what is your trigger? We need to figure this out so you can continue to do your job. Because, for example, if someone has panic attacks that are a result of a particular customer, client, or situation, maybe that's something we can accommodate and say, okay, you don't have to do that. Maybe we can move you from, this territory to another territory and still have you be able to do your job because we're going to eliminate that trigger. But Ms. Johnson refused to engage in the interactive process, so she was fired and she filed suit. The court held that disabilities, including anxiety and depression, do not insulate an employee from misconduct, just like the Kentucky court in Gravity Diagnostics. And again, emphasize that we have to engage in the interactive process, something Gravity Diagnostics did not do. Here, it was the employee who failed to engage in the interactive process. So I want to remind you, please document in writing. I can't tell you the number of times it has saved our clients when I see an email that says, dear Claire, please come and let's talk so we can engage and engage in the interactive process to talk about your impairment and how it affects your ability to do your job. If it's not responded to, that's great evidence. So again, the example of someone having an outburst at work to a triggering event might need an accommodation so long as it qualifies as a reasonable accommodation. But you can't just not engage in the process and on either side. So unfortunately for Ms. Johnson, she lost her job and her lawsuit. So again, the takeaway from this is make sure you train your employees on their obligations to engage in the process. They can't just say, I've got a disability and disengage. And the training, I think every aspect of Scary Stories today is about training, whether it's AI, non-competes, social media policies, the same with your obligations under the ADA. And again, mental health issues are the single most difficult under the ADA for us to analyze and deal with. And so it's not going to be an excuse for poor performance. So we need to identify what accommodation is reasonable, and it's a very difficult process to go through. I want to end today with a discussion about FMLA abuse because it happens, and I love this case. I think it is interesting. So this married couple worked for the same employer and were both certified for intermittent FMLA for different reasons. The employer became suspicious because the couple began to use their leave in an overlapping fashion. And it extended beyond their doctor's certification that, they might need leave for 60 days or 45 days or whatever. So instead of just jumping to conclusions or feeling like you're held hostage because someone has an FMLA certification, the employer engaged in what I thought was fairly objective analysis. Checked on absences and found that they had 21 common full day absences, 27 common partial day absences, and disciplined them for abuse. The husband alone filed suit for some reason, which I find to be curious. But he loses his lawsuit because he could not point to, or he claimed that the employer couldn't point to a single day that was used illegitimately. And this case highlights, obviously your ability to manage FMLA abuse, what options you have. And the court ultimately is going to focus on the honest belief rule. First of all, it's the employee's burden to prove that the suspension or the adverse action was because they took FMLA. Here, the employer had an honest belief that it was being abused, conducted an investigation, found objective criteria, and made a disciplinary action based upon that. The honest belief rule will protect you in a lawsuit from the employee being able to establish that the quote, legitimate reason was pretext for retaliation or discrimination, so long as you have evidence to support your business judgment. And that's truly important in these types of cases. And again, I don't want anyone to feel like they're held hostage by someone because they've made a claim, they have a ADA accommodation, or have FMLA leave. You have rights. You can seek recertification every 30 days unless the certification is for longer. So if I say, oh, I need to take intermittent leave because of migraines and it's going to last for the next 45 days, at the end of the 45 days, you can ask for additional certification, and you should. It's expensive. Employee has to take time off. The doctor may charge a $75 fee for the certification. And physicians are getting more reluctant to just rubber stamp some of these requests. So, I want you to take the steps that you need to take and use statistical and objective evidence. Make sure your FMLA policy has a statement that says you will be subject to discipline for false or misleading information related to a request for leave. That's super important. It was helpful here. And again, you have the right to certification. So I am 2 minutes overdue, but that is the end of our presentation. I don't see any questions in the chat box, but here's our contact. You can email Claire or me with any questions. We obviously appreciate your time and your, willingness to join us, and we're here for you. Claire, is there anything that you would like to?
No, I think you covered it. Thank you so much for participating. We appreciate it.
Please don't copy and paste those photographs of us on any social media site. I have to talk to Brian about that.
Yeah.
We'll be sending around an email that contains both a link to the recording and the slides. Feel free to spread that around as much as possible if you'd like to, and contact us if you have any questions. Thank you very much.
Thank you.